Good evening and welcome to Slam the Gavel, the show that tells all regarding family court, criminal court, and other court issues, as well as CPS. I am your host, Maryann Petri. You can find me, my books, and blogs on dismantlingfamilycourtcorruption.com. They are in audio as well. You can find them on Amazon. Raised by These Wolves, Volume 3 will be coming out shortly within the next 2 weeks. And I have another announcement in Colorado on November 19th at 12 p.m. at the Denver Capitol. There will be a Men and Families March for parental rights. Systems are exploiting families and not protecting children, per Carl Roberts, who I've had on my podcast before. This is November 19th, 12 p.m. at the Denver Capitol in Colorado. So I welcome back Marc Fishman. He's been on my podcast 6 times, and he is waiting for the Court of Appeals regarding his imprisonment and appealing his conviction. And we're going to talk more about that. And I'm very sorry it has been going on this long, Marc. How are you?
Hi, Maryann. Thanks for your advocacy. I'm alive, well, and healthy. It's good to be able to go on your show and spread advocacy and share the journey so many of us go through with the family court mafia, particularly those of us with disabilities. So
Mhm.
thank you again for having me on, and thank your audience for listening.
I'm glad you're on and speaking out. A lot of parents are afraid to.
It's true. When I first started my journey, which was basically to file a federal lawsuit against the New York court system um, in 2018,
Mhm.
I was terrified. You know, I mean, I was going to cognitive group classes, for therapy, post a devastating car accident where I got hit by a van from behind and
Oh,
suffered traumatic brain injury, tinnitus, ring in the ear, occipital neuralgia, which is severed nerves in the neck injury, post-concussion syndrome, cubital tunnel syndrome, broken knee, torn cuff, torn rotor, numerous orthopedic injuries. And yet, family court just expects you to continue, paying support and, chugging along, even though you're trying to put yourself together medically in rehab. And even though you weren't at fault, I was rammed from behind, dropping my kids off at school,
oh,
dropping my eighth grade daughter off at school with two of my four kids in the car. And that was June 10th, 13. And, Maryann, I can tell you that, basically everything in family court has been a loss before my federal litigation to highlight the fact that family court opposes reasonable accommodations and auxiliary aids for those with hearing, memory, mobility, and other impairments. And again, thank you for allowing me to come on your wonderful show to amplify this and spread awareness and tell others there is hope and now legal precedent, so that hopefully they're not denied accommodations, or their friends and family are not, when they go to family court or divorce court, or just state court in general.
right. And I hope nobody goes to family court. And we were talking earlier as to why are these lower courts criminalizing parents even afterwards or during or afterwards?
It's very sad, Maryann, but it is unfortunately a game of retaliation. I mean, a lot of your viewers know me, so I sued the court system as well as the court staff and the family court judge for denying me a note taker, for denying me an aide, for denying me a tape
Mhm.
recorder, or what I use on your show right now, commonly known as captioning, closed captioning. The words on the screen, because the way my system is rewired post accident, I register words better by seeing them in writing than by hearing. I have spinning in my left ear for tinnitus. I have constant headaches, and so
Okay.
when I see the words that are processed as you talk, and that we get on Netflix, we get on airplane watching a movie. We now,
Right.
if you download the Google app, Maryann, you now get it on all your Google phone calls. It just says closed captioning, push button, and it does it.
Well,
So
that's good.
that was denied me, and yet you have a judge saying you don't remember my oral orders, and um, you don't follow instruction. And I said, Judge, I need help taking notes, and I need help to see the words. And she said, take your own notes. You imagine that? Take your own notes. And what is more cruel, right, Maryann?
Oh, these judges don't care. Even when I was going through this, I don't know if this was happening in your case, but they only want to hear what happened in the last 2 weeks, not what led you up to the point of all of this.
You're totally correct. So for those of you who are aware, a lot of people know carpal tunnel syndrome. I have that bilaterally, both hands. But I have something additional called cubital tunnel syndrome. Have you heard of that, Maryann?
Huh.
Oh, so cubital tunnel syndrome is your elbow. So
Okay.
nerves at your elbow. So basically, in the car accidents, the nerves in my elbow got rammed, and basically, I lost feeling in the nerves. So I cannot hold a pen or pencil well either hand to take my own notes. So I didn't ask the court to pay for my note taker. I didn't ask the court to pay for my aide. But no, they were denied entry to the courtroom. This after the court system said you can bring a note taker in. Hence the federal lawsuit after the judge, Michelle Shower, in Westchester Family Court, jailed me, saying I don't remember her written orders is false, and saying that my claims of not remembering or registered orders belie the record. And she said, I remember when I want to. This after a 6-day hearing before, where she agreed to accommodations for my disability, but then at court blocked my note taker from entering the courtroom. Literally blocked it, with her court attorney, Michelle D'Ambrosio. So, Maryann, that resulted in me being jailed for 2 weeks in a jail hospital because, as I said, I am disabled.
Hmm.
I have two neurostimulators, one each chest. There's one.
Hmm.
So if I go near the magnetometer, or what we see is the magnetic X-ray machines, my stimulators heat up and they could rupture, and I could die, and I could be of harm to others because they can rupture and cause other damages. So putting me in jail, not being able to go through magnetometers, you're throwing me in a jail hospital with no access to services. It's like, for example, since my car accident, I can't lie flat in a pillow. I lie arched, right?
Hmm.
No pillow for you, Fishman. Why? You torture? So my neck had a
Hmm.
bunch of holes in it after going there 2 weeks, was red, and infections in my neck because lying flat without having access to a quote unquote pillow. Why wouldn't you get a pillow? Oh, you might suffocate yourself or suffocate another prisoner. Really? I have no record. Suffocated for what? You know. And they said, well, in the regular jail, we have bumps in the vinyl bed. I'm not in the regular jail. I'm in a jail hospital. Well, tough. Tough. Oh yeah. So in our world, we call that cruelty.
Right.
So by injuring my neck, you basically set me back a year in rehab, and the stiffness and the pain and all of that, and having holes because your electric stimulation is still on, and you're still zinging up the neck. But meanwhile, you're laying flat, and yet your nerves are injured. You can't lie flat. You're permanent neck injury from the impact of a heavy impact collision. And the judges knew I was disabled. They had their own experts. As you're aware, these forensic experts, they all said you're hearing impaired. They all said you're memory impaired. They all looked at the reports, and they also talked about mobility necessitating an aid. And you have Judge Michelle Shower saying, oh, well, if you need aid, then you can't see your kids, or you can't see your kids alone. Or you know what? If you need aid, you can't be a good parent. And it's sad and atrocious that these people wear a robe, and that they're allowed to practice. And I just think of all the other disabled people who can't fight for themselves, who don't sue in federal court, who don't, get an ordering the accommodation. It's sad. Here we are in 2025, and
Mhm.
we're talking about a family court judge fighting the diagnosis of the medically ordered personnel that she ordered, telling her you're hearing impaired, you're memory impaired, you can't write, you need an aid, you use an aid for your other services, so use it for court and court programs. She says, no, that's an excuse that you can't parent your kids. No, that's an excuse that you should be disbarred, removed as a judge, okay, and maybe
Right.
spend some time in jail. I'll let you be in a jail hospital so you can see other disabled people try to function day to day without accommodations and auxiliary aids.
I know this is going to sound strange, but can't you say that could be attempted murder of you being jailed?
Sure, you put two and two together. Is that the people in Westchester County Jail where I served the 2 weeks? They don't want you there. A nurse's doc don't want you. You're a liability.
Right.
They got to keep 24/7 looking on you. They know you're disabled. They know you're a high risk. They know you have a high potential for injury. You're not walking to visitation alone.
Mhm.
You're not being escorted to the doctor alone. You need 3 or 4 guards. You need plenty of resources, because if you get injured on the judges on the warden's watch, they're done. In my case, they got advance notice from the ADA liaison in Westchester County, Evan Latainer. My ADA advocate, Donna Drum, was a partner in the Bowie's law firm, the firm that represented Al Gore in the Gore versus Bush butterfly bat election, as well as my nonprofit advocates at Disability Rights New York and the Brain Injury Association. So believe me, they don't want you there. The cost, Maryann, the cost is thousands of dollars a day if they put you in county jail because of resources that they have to apply and use for you because you're disabled. But according to family court Judge Shower and our cohorts, no, you're not disabled. You fake it. You're too smart. You try and pull a fast one. So we have to punish you because of your disability, because your disabilities are intentional, and you don't remember, don't hear, or don't write intentionally. It's sick.
It is sick.
It's
It is
sick.
sick. I had a child support judge saying basically the same thing, even though none of this should have happened to begin with. Just like your automobile accident, you can't, that's out of your hands. You can't control that. There's some things in life you can't control, and these child support judges don't care or get it.
You said it. you know, which again, I want to thank you for putting me on this podcast, because,
Hmm.
I was actually looking over the records. I have my personal injury trial coming up at the end of April for my auto accident from 13. The Bronx is where I live, and, it's very backed up courts. And they actually said they want to utilize my podcast with you, Maryann, and with others, to say I don't have traumatic brain injury because I can talk on a podcast. I have 2 neurostimulators that are on.
Right.
I'm using closed captioning. I've made everything quiet in the room I'm in with no noise, even shutting off ventilation, air conditioning, so I don't hear an echo. But yet, if Mark can go on a podcast and he really isn't disabled from traumatic brain injury, what? You know, you'd be amazed at some of the ridiculous excuses and how they try to escape liability. You
Mhm.
know, I have a court order from September 2013 that the people that hit me in the van are 100% responsible for my injuries, neck injuries of occipital neuralgia, and the disabilities. Okay, and my inability to work for a number of years. Oh no, we're going to challenge that. Really? A judgment doesn't matter. You're going to have to pay interest on whatever judgment we get back to 2020. Let's appeal it. They did appeal it. They lost. Okay, and you're on trial calendar, so we're going to go to trial on damages. Oh no, you can't be this disabled. You can't be this disabled.
Yeah.
You know how fast that van was going to ram me?
Hmm.
The seat motor in my seat broke. My rear tire had a gash. The electric and air conditioning were knocked out. Oh, but your car doesn't show significant damage. Yeah, but I do. You hit me with a plastic bumper in a Ford minivan against a aluminum reinforced metal bumper in a BMW. And you want to know why your bumper is bent in and my bumper only shows minimal damage? Let's see. If you hit a tank, the tank's not going to show as much damage in your little plastic Ford. But this is the nonsense they say.
It
This is
is.
the nonsense. And Maryann, just as a side note, I have a good friend of mine, Kim Hill, who is the director of accessibility for New York State. And she was in a simple car accident where she was hit from behind. And she was in a sedan, and she was hit from a sedan. And similar mile per hour. And she is a paraplegic. She is disabled from the waist down. Everyone gets injured differently.
Right.
I was lucky. I worked out with a trainer, Big Mike, for 14 and a half years. I had back muscles, shoulder muscles. I had strength. But when you ram me, you severed nerves in my neck, and caused all these other nerve injuries like bursitis in the left leg and neuropathy and the cubital tunnel, carpal tunnel, all nerves, because you rammed at such a high speed and you impacted. And people say, well, if you were hit at such a high speed, why aren't you paralyzed? Well, I worked out with a trainer and did back exercises for 14 and a half years. I'm lucky in the sense I'm
Yeah.
not paraplegic. Oh no, but you can only have these injuries if you're paralyzed, huh?
I,
Do you see my nerves? Do you see the nerve conduction studies? Do you see the stimulator they put in on my neck to vibrate so I don't feel pain? Oh, you can't be this injured. You know what? Give me a jury. Give me an honest jury.
Right.
Let all my doctors testify, and we'll show you how this can easily happen. And I'm very lucky that I had these muscles, but this pain, nerve pain, neuropathy pain, pain in your elbows, pain when you write, you try to write, pain when you try to hold a pen, pain when you try to sleep. Man, this is torture. So to lose your kids on top of this, my God, it's cruelty.
In, can't your ex stop all this? I don't think I would put my ex through this, to be honest with you. I'm not
Mine
that
has
type.
no morals and no ethics.
Well, neither
Okay.
does mine, but I mean, you're talking about jailing the mother or father of your children. Can they just back up the bus here because this is going to affect the kids long term?
Sure, it has. Think about it. You're seeing your kids regularly, even this mafia family court system, in my case, from 2013 straight through to 2020. And then the court stops it during COVID, stops virtual, right? Okay. Yeah. Of course it's affected kids, Fabi. How could it not? I mean, it's horrible. The system looks inward to protect itself. So basically, continuing our conversation before, after Judge Shower jailed me for her 3-week sentence, okay, for not remembering orders and saying I violated an order of protection because I sent gifts to my kids
Hmm.
on holidays that she said weren't major holidays. She gave written orders that said you are to only send gifts on holidays. And I sent gifts on July 4th, on Memorial Day, on Easter, on Passover, my kid's birthday. Okay. And Judge Shower took the mic and said, those aren't major holidays. I told you there are no holidays between March and July. Go to jail. Now, my daughter had ordered on the Amazon account. I'd given her $1,000 gift card, a year before. Lots of gifts came. No, Mark used to go to jail. Why? I didn't see the word major on your order. Your order was interpreted by a number of attorneys and ADA advocates for me. Okay. I followed your order. And I said, where's the crime? It's the fish. You don't get it. You do things when you want to, and you interpret your words in a way that I don't say them. Well, Your Honor, how am I supposed to get them? There's no live court reporter in the courtroom. We get digital transcripts or analog ones. It could take up to a year, and you don't allow my note taker, no tape recorder. And you're telling me you said something verbally, which, of course, after your 9-hour day hearing, I'm not going to remember.
Oh,
Okay.
yeah.
But expect me just to remember your interpretation of something. Basically, you're setting me up to fail. You have a memory and a hearing impairment. It doesn't matter what your intelligence is. If you don't have the ability to remember, or don't have an aide or someone to take notes, or don't have this real-time transcription to process it the way a lot of us process things in writing, to see them and then they process through our head, then, you are going to fail. And then you get to the process, Maryann, what you say is the court wants you to fail. The court wants someone to be the villain. The court wants someone to be evil,
Hmm.
because a lot of these family court judges have no ethics and morals, and no conviction to help the disabled, and the veterans and the helpless. And they want someone to be evil so that they can say, okay, take away everything. And, oh, I'm so great because I held up the quote unquote good parent. What good parent?
Right.
It's what you said. There obviously isn't a good parent on the other side, because a good parent would not allow persecution of someone with disabilities, particularly when we have a disabled son who's autistic.
Hmm.
Denying me access to him when I could relate to his disabilities and get him accommodations faster than anybody else, because of my connections to the disability community, because I'm on several disability boards, and because of the fact that I've had to, fight for accommodations for myself and sue in some cases, that would be helpful to our son. No,
Hmm.
she wants to portray it as I'm evil. And the real problem here, Maryann, is why is a state court allowing her? Why is state court allowing other judges to persecute this way? And that's where we really come to the answer, which is, publicity, awareness, education of accommodations, and federal litigation with some new laws. If you're not going to pursue things federally, a state court is going to protect its members, its employees, its agents, right? And then, they're only going to take an issue when they get ordered to stop, which is typically, in our case, federal court.
Right. It's like these state courts, they're just money courts.
You said it. You said it. So the fact that after that experience where, in jail, especially the jail hospital, you lose any sense of privacy, court medical staff and jail medical staff and jail officers and security. They looked in places on my body every day, multiple times I didn't even know existed. So you have no privacy. There's no privacy. There's no anything. But what happens is you make the decision for those of us fighting the good fight and fighting for law and order and fighting for disability accommodations to sue you in federal court, which I did. So that federal lawsuit against Judge Shower and her staff made it several years, through the system where Judge Karras would not dismiss it right away, and made the court answer, why did you deny access to a note taker? And made it explain, why did your staff block the note taker? And your staff blocking a note taker from the courtroom when the court system said he could have the note taker, but the judge didn't, is discrimination. Ultimately, the judge, before COVID, dismissed the case. But on appeal, the Federal Second Circuit on July 16, 2021, issued a 2-sentence order against Judge Shower, 5 other family court judges, her court attorney, Maryann Petri, who blocked the note taker. They issued the order against Nancy Berry, the head of the court system, that's saying the communication accommodation for Mr. Fishman's qualified, acknowledged, and regarded disability are hereby ordered to be provided by the court. Mm-hmm. And so that took over 50,000 transcripts, over 100,000 legal fees. It took 3.5 years of litigation, right? And so the court system says, okay, we'll provide communication accommodations to you now going forward. What about all the trials and cases in the family court where you ruled against me? Oh, tough. You can go to the appeals court, try to get them reversed. No, they're not reversing anything. And we'll give you closed captioning, and we'll give your note taker access now, July of 2020 forward. But screw you in the past, and screw your kids, because we're not going to acknowledge you did anything wrong, but we'll follow it now. It's a disgrace. It's an embarrassment. It's an abomination. Right. What it did lead was I did testify with the State Senate Judiciary Committee. I did testify with Edwina Mendelson and our Committee on Accommodating Courts. And it did lead to Part 52, which you can see on our website, NewRochellePoliceAbuse.com. Again, NewRochellePoliceAbuse.com. So Part 52, as of March 2024, means that if you are a disabled person and if you request an accommodation of the judge, you do so confidentially. The judge can communicate with you on that without being subject to discipline or violation of her oath for not communicating with the other side or with your adversary or with the attorney for the children. Meaning that you can ask for your accommodations to the judge and have a conversation or have, a meeting, or we use the term a process by which the accommodations are decided. And the judge has to respond and has to say why they're granting it or not granting it, and cannot share your medical information. And they cannot solicit opinions and input from your adversary as to whether you should get the accommodation. So that was Rule Part 52 of the Chief Judge Wilson. We're grateful for it. And a lot of judges, new judges abide by it and, have no problem and want accessibility because they want fairness and they want to be known as giving a neutral, impartial judicial forum. But some of the older ones, like Michelle Shower, they view it as a direct insult and attack on their credibility and their quote unquote ego. And if you can imagine, after Judge Michelle Shower, after being told that she can no longer be my judge in 2018, when I returned to court on parent alienation charges in April of this year, Judge Shower took the case away from 2 lower judges. Even though they're all family court judges, she's now a Supreme Court judge in family court because she can't get elevated because she was caught discriminating against me. So she took the case and was very clear that she wasn't going to abide by any Part 52 or review any accommodations, and she resented it. And she was also very clear that I was not going to have a parent alienation hearing in front of her, even though we found parent alienation charges in front of 2 other judges who gave me an abatement of child support of $49,000. Oh, she wasn't going to see that. She's going to get her retaliation for me taking her all the way to the Supreme Court with that case and getting an order for the accommodation. And, Maryann, it's like you should say to yourself, the judge should be humbled any judge should be humbled or educated when a federal Second Circuit, a federal group of appeals judges, right under the U.S. Supreme Court, say a disabled person should get accommodations. You should be humbled. You can apologize. You can say you're educated now. You go forward. No, no. Judge Shower felt this was retaliation, personal attack, ego hurt, and retaliating from me against me and others who complain against her because she'll never be elevated outside of family court. She did that to herself, her own bias and discrimination. She should be fired. But the New York State courts protect each other. If they fire her, she'll tell on other judges, and we'll all get fired. So, so she denied me a parentation hearing. And then she went so far as to say, Maryann, in her pompous, egregious, selfish, self-centered ego, and Mr. Fishman, your order against me is only against me in federal court. It's not good in state court because you only got in federal court. So when you sue me in federal court, you can only get your accommodations in federal court, not state court, because state court didn't recognize the order. And I said, Your Honor, do I have CART closed captioning right now? CART reporter, can you please announce yourself? She said, yes, my name is so-and-so, taking notes. Your Honor, why is the court system requiring you to have real-time transcription now? CART, real-time transcription, if it wasn't ordered. Okay, Mr. Fishman, everything you say is a lie. Everything you say is false. I said, Your Honor, I'm a meat and potatoes guy, Bronx guy. Okay. If an order says communication accommodations are ordered, it's ordered. But Your Honor, in the order, it doesn't say it's only good in federal court. It doesn't say it's not good in state court. It doesn't say anything you just said, which is another reason why you should be off this case. We were told by Office of Court Administration you never appear again. Why are you so interested in this case? I'm a very boring person. Okay. I have a battery in the right and left chest. I'm someone who lives in pain. Okay. There's nothing flashy about me. Okay. Why are you so obsessed? And this is what is sad about some of these judges. They have an agenda. Oh, yes. Marshall served you in 2018 when you denied a note taker, and they served your court attorney, and they served your other judges. You don't like that? What do you want from me? I didn't order the federal marshals. No, Mr. Fish, you ordered the federal marshals. They came because of you. They came because of your lawsuit. Your Honor, I have no power. Judge Karras ordered the federal marshals. Here's his secretary's name, Mary. Here's her direct number. If you don't like the fact that Judge Karras ordered the marshals for you to be served in this lawsuit and sent them to your house and your workplace and your chambers and to your staff, I'm sure Judge Karras will give you what you didn't give me, a forum to be heard, to voice your complaint. Every time I want to voice my complaint, Judge Shower, you either say, I can't talk, or shut me off, can't bring a witness in, and just, rule from the whim, in solidarity with some false sense of giving an opposition ex-wife, total domicile and total control and total access to her kids at my expense because you don't have the patience, empathy, sincerity, or compassion, or humanity to show a little bit of concern for someone who's disabled, who's trying to recover from his life after a devastating accident. You shouldn't wear a robe.
Right. No compassion, almost psychopathy.
You said it. So when you say, is it like murder? Yeah, Maryann, I was just on the Roger Stone show late September 24th, and it was WABC Radio, and I felt compelled to talk about three women, one of which I knew very well, Julie Goldfarb, Elizabeth Hardin Weinstein, and the lady who committed assisted suicide from Larchmont. I'm sure the name will come to me. That's TBI.
Oh, the attorney.
You know who I'm talking about, the federal attorney.
Yes.
The name will come to me. But anyway, I knew Lizzie Harding Weinstein actually very well. And we had some of the same judges. We both had Judge Malone in the Supreme Court. And Lizzie was, jailed during her family court divorce proceedings and put under some sort of, evaluation for mental therapy, some ridiculous charge she didn't have, and, no due process, no charges. And I'll never forget, I mentioned the three names because these people are dead. As far as I know, the three of them committed suicide. One was assisted suicide, the lawyer in Switzerland.
That was Catherine Youssef.
Pardon me?
Catherine Youssef.
Catherine Kasanoff, right. Yes. Yeah. Kasanoff. Yes, thank you. Yeah, they teach us in TBI therapy, Maryann, if we continue to talk about it, think about it, the name and will come to us.
Well,
Yeah.
it's because of the trauma of of being hauled into family court, the ex who is putting you through family court. And I know we both have heard that, well, you've got to put the blame on the judge. The judge should be blamed for allowing this to go on. Okay, I kind of agree with that. But also, who is the driving force? That is the exes and their vulture-like attorneys. There's blame
And
everywhere.
and the court system that supports him. Because in my case, Maryann, Judge Shower never allowed any of the experts to testify. I went for 19 evaluations. Why don't you let them testify? Oh, well, Mr. Fisher, I disregard all of them. You made me spend $165,000 on them. Well, you disregard them. They're admitted in our appellate division. In order to be a psychological or neuropsych or a psychiatric or social worker expert in Westchester courts, you have to be admitted into this grouping of professionals that's maintained by the appellate division first and second department. If anyone goes in the appellate division second department, they can look at list of approved court evaluators. So we had over 12 of them. No, you can't use them. Why? They all said I'm disabled. They all said I'm a great dad. Well, that's why you can't use them. I disagree with them. Well, let them testify so we can exercise the rights on appeal. No, I don't have to, Mr. Fishman. I don't have to do anything. It's my court. You know? So, Maryann, what was the purpose of the evaluations? What was the purpose of going? What was the purpose of this? Well, we don't care. The purpose was, make you borrow more money, make you pay 30% credit card interest, make you unable to pay your obligations, because keep in mind, a support visit for me meant a supervisor at $500, a limo at $100, okay, food for the kids at lunch for my two days a month, okay, an aide for me, and you can see your kids twice a month. So you want me to spend like $12 to $15 to see my kids, okay, because you have some misperception that a disabled person who has an aide anyway, who has help anyway, is deficient and
Or
unable to parent.
or is it a vendetta?
It's totally a vendetta. It's totally a vendetta, and they have the power control, and that's why we do this federal litigation. That's why, they're so intent on jailing those of us
Mhm.
who have pierced state sovereign immunity, who have pierced judicial immunity, who have pierced immunity of the judges. I mean, under Judge DeFiore, who was our former chief judge, they adopted the policy during Floyd of zero tolerance. If you discriminate against a disabled person, you're fired.
Mhm.
But try to get to another judge to say another judge discriminated, even if they're a Republican ultra MAGA against a Democratic liberal judge, you'll never hear that judge 99% of the time saying that he or she found another judge discriminated or violated just judicial oath, because they know, if I say that against the other judge, the judges will come back and tell me that I'm like that. I'll lose my pension, my robe, my car service, my limo. I'll lose all the parties, the designations, the honoraries, the free dinners, all this stuff. So you are not going to protect disabled people and disabled veterans because you're so concerned about protecting your robe. Your robe is meaningless if you have no empathy and no ethics and are ignoring basic civil rights and basic disability rights.
And one of my friends was listening to you speak on this podcast, and she said she didn't realize all these ADA rights and violations. And she looked them up in her state, and she said she was so glad she listened to you because she had more help in her case in
Thank
another
you.
state.
That's why I come on. My daughter Joanna graduated, from SUNY Binghamton in February. This past spring, excuse me. My son Jonah is 20 and a half. My twins are 17 and a half. At 18, we'll lose this whole, family court ability to come in for any visitation or custody. They've already prevented me from filing things and already denied to basically ensure that I won't get anywhere until after 18 or even then. Matter of fact, Judge Shower, in response to the retaliation requested from my ex-wife and her own sense of anger and resentment, stopped my access to school records in violation of FERPA in the spring. And the appellate court, who was overruled in Brooklyn, Judge Hector LaSalle's appellate court, Judge Hector LaSalle, who was rejected to be our chief judge in the Court of Appeals because he denied civil rights accommodations to me and four others. Judge Heckler upheld Judge Shower and Judge Capici's denial of real-time transcription and denial of an ADA advocate for my son, and then was overruled by federal court ordering the accommodation. So I've appealed to Brooklyn, which is our direct court, to lift the illegal restriction of access to school records and school computers and that stuff. And Maryann, they haven't even responded to the motion that was filed last week of June. It's November now. Most motions are resolved in a month or two. So you know it's retaliation. Oh, it's retaliation. Fishman called us out. Fishman, got an order and it's publicized across the country for, helping people with, brain injury, like Alzheimer's victims, Parkinson's, dementia, traumatic brain injury, autism. So I helped everyone who is in New York State who can now bring a note taker easier to any tort of state court, and who now knows about CART, which we call real-time transcription, that every courtroom has it since 2015, and it needs to be turned on. It's not a question of does the court turn on, or does does the court think you're disabled or hearing impaired enough? Maryann, that's the other travesty here. Here we are, and the court administrator says you could have a note taker, but if the judge denies it, you gotta sue the judge in an appeals court, or go to the ADA liaison, or go to the Commission on Judicial Conduct. I went to all those people, all those groups, because then they can order the judge to do it. We can order the court to have the accommodation in New York, like a note taker, but if the judge doesn't allow it in, that's your problem. No, that's your problem. You pay her a check. She works for you. And if you don't, go to federal court. Federal court on July 16, 21, in case 20-1300, ordered the accommodation. Because they ordered it, I'll never win anything in family court in New York. The retaliation is that upstream until we go to and get concluded in federal court. And that's what we lead to our conversation today is, like you said, the criminalization of parenting. So what happened in December of 2018? I was following my visitation order with Supervisor Ann Elliott, who we had on your show last time, a whistleblower who came forward and said I didn't violate any order of protection, didn't commit a crime. Yet I was arrested by Officer Lanes last year on December 15th, 2018, for violating an unserved oral order of protection that Judge Shower allegedly issued when she jailed me for sending gifts to the kids on holidays she felt weren't major. The order was never given to me. It was never given to Ann Elliott. It was never given to my attorney. It was never given to my disability advocate. But guess what, Maryann? It was given to my ex-wife and her attorneys. Oh, and the cops
funny
had
how
it.
that works.
And it said complete stay away order. But next to the order, it said, oh, there's another order for visitation. With a car visitation. Well, guess what? Ann Elliott and I, 2018, were following the visitation order. We never got the other one. Okay? And so when I went to complain on December 15, 18, after I was driven by my disability aide during my hours of 10 to 5 to go see, in this case was my autistic son, just having a visit, one of the four. The other three were not home. Then went to the police station and told the cops I needed my communication aid to explain the orders and everything. And instead of the cops accommodating me and allowing my aide to help me and giving me a note taker if they didn't allow my aid, they just arrested me and said, you violated order of protection because you shouldn't be in the city of New Rochelle. They didn't listen to my need for accommodation. They didn't read the 28-page visitation order. Yes, 28 pages. They didn't go by the order of protection, which had a carve out. They just said, you're guilty. You violated order of protection. Wait a second. I need my aide to explain this to you. I need her to get to the car to show you all the orders. I need her to go over this. I need a pen and paper. I'll try to explain it to you, or she can try to write it down. Denied. Here's my brain injury card. Denied. Here's my implant card. It says I need a note taker. I need an aide. I need a time. I need pen and paper. Denied. You're just guilty. Go in the back. What? And so that resulted in criminal charges. Okay. Against me and an ADA second ADA Section 504 disability discrimination lawsuit against the cops for failing to accommodate disabilities. I grew up thinking the cops were all just. You go to the cops if you need help. No, the cops, unfortunately, are on a mission to meet quotas to find someone guilty so that they can charge them and meet their quotas and pretend that they're protecting the community while discriminating against disabled people. And so that began the whole journey. Like, what do you mean? I sued the cop 3 weeks later. Said you denied my aid, you denied me accommodation. You don't read orders,
Right?
You don't accommodate. And asked for video from the police precinct. Oh, no video exists. Oh, the 4 cameras are sitting. Oh, they're not on. They weren't recorded. They weren't on. They're out of order. You know, and the lawsuit proceeded. I'm happy to say we're still in court now. The cop has been fired. His name is Lane Schlesinger. As a result of my federal litigation. As a result of my federal litigation, not only does New Rochelle now have a policy where you can register accommodations you need in advance if you do any business or live in New Rochelle, they also fired the police chief. They also fired the supervisor. Okay. And, there's been a lot of positive reform while, again, denying everything. But we're forced to give over the videos. The video showing the cop, Lane Schlesinger, telling my disability aide, Isabel Bovar, Mark had no intent to commit a crime. Mark did not commit a crime. I don't think Mark committed a crime. Mark didn't commit a crime. Jury never got to hear that. Jury found me guilty in state court. I never got enhanced discovery. They said the cameras weren't working. But until those cops had to swear on the Bible and come to federal court that they had no video, there was no video. Fishman's never going to get the video. Fishman's a disability punk. Fishman's a punk. He sues us. He has process service go to our house. No, Fishman advocates for civil rights for Fishman and for other disabled people. And by getting the cop fired, we've helped thousands avoid other incidents of discrimination from him, his supervisor, and the police chief who condoned it. And Maryann, in October 2023, we got the video. Okay, the video they withheld. The video that the cops had all the time. Oh, yeah, it was in our desk drawer. Oh, really? Yeah, why didn't you give it to us? Why are you saying it now? Oh, no, we couldn't find it. You couldn't find it? It's got digital backup. Oh, we have it now. Oh, we're going to certify in federal court. So you play his games. So you go back to criminal court, you say, dismiss my case. And they say, no, we're not going to, dismiss anything. Then you go through the whole nonsense of delays and appeals where the state court says, if Fishman gets the charges reversed against the cop, it'll be really told that the cop called Judge Shower, who told Fishman, told him to arrest Fishman no matter what. Anyway, that's what really happened. If anyone does business in New Rochelle, they know the orders of protection are served by the cops. The order of protection in question was never served by the cops. Matter of fact, my good friend Maryann, the order of protection that I was charged and convicted of violating was 3 pages. But only 2 pages went to the judge. Of course, I didn't know how many pages it was because I never got a written copy. All I got was the transcripts that said any order of protection is subject to visitation and listen to Ann Elliott, right? So what didn't the jury hear? The jury didn't get to hear page 3 of the order of protection. Party not served. Mr. Fishman not served. Mr. Fishman not served, right? Jury didn't get to hear that. Oh, can we get a new trial, Judge? Oh, no, we can get a new trial. Why? Oh, you're guilty. Let's continue order of protection. Can I get sentenced, Judge, so I can appeal this? No, we're just going to continue order of protections.
Which are served out like candy, these order of protections.
Yep. So here we are, after 2 years of trying to get sentenced, I got ill. I got cancer in my colon, and I had my implants infected and then needed surgery. Couldn't physically go to court, couldn't physically travel anywhere. On the West Coast for rehab and for specialized surgery. Where I have access to care in a disability-friendly state of California where they accommodate people without us having to fight for it. They say, you're a fugitive. Why am I a fugitive? I attended court 9 times in person to be sentenced, 1 time virtually to be sentenced to get an order I can appeal. Okay? Oh, we're not going to give you that. You have to come in person. Come in person for what? They recommended 1-year order probation. I have no criminal record. Oh, no, Fishman. You got to come in person. We're not going to send you. Well, here's an accommodation. They say now, you give accommodations during COVID. They're giving accommodations in Bronx civil court for me. They're giving accommodations in family court. We have child support court. We even have family court hearings. Why can't we have an accommodation criminal court? No. That's discrimination. That's just total discrimination. You just can't keep open orders of protection year after year because you don't like me, because you were sued because a federal court ordered accommodations. And by the way, you should have a new trial because at the trial, I couldn't hear witnesses. I couldn't testify because you didn't turn on real-time transcription. You blocked my note taker. Oh, who cares? You're guilty no matter what. I said, Judge, did you even read this February 26, 20 order? Yeah, who cares? The February 26 order was confirming that my ex-wife was due an order of protection, okay, because of the kid's perception of their father's behavior with his brain injury. My behavior? You mean I get bloodshot eyes with a occipital neuralgia? My face turns red. I get hives on my chest when I have a rash or when there's an infection? What behavior? I have witnesses. There was no behavior. You're going to teach kids to accommodate, have empathy for disabled people, or you're going to label us. But in that order, Maryann, on February 26, 20, which was less than a month after our trial, which ended on January 27, 20. The appellate court wrote in Brooklyn, Mr. Fishman's order of protection is upheld. He is to stay away from the wife, the kids, school, and the workplace and home, except EXCEPT, except limited supervised visitation per court order. So less than a month after trial, they have an order from family court codifying that the activity I was doing, being 4 hours away when my supervisor went to pick up my disabled kid for a visit, was allowed. But is Judge Zuckerman, who was sued in federal court for discrimination, going to reverse his order? No, he got served by marshals. He's embarrassed. Judge, we're now in 21. Okay, sentence me virtually. Give me a new trial. I couldn't testify because I couldn't hear witnesses. I couldn't read lips. You had the witnesses too far away. Look at the transcripts. I didn't talk. No, Mr. Fishman, you're not disabled because Hector LaSalle at the appellate court said you're not disabled. He was overwritten. Oh, Hector LaSalle is his own judge. He determines his own order. I said, no, Your Honor. I said, Brooklyn Appeals Court is here and federal court is higher here. He was ordered. Mr. Fishman, we don't care. We'll have an order of protection. You come here, you get sentenced. Get sentenced for what? I didn't violate anything. The cop said I didn't commit a crime. Oh, who cares? So eventually he was removed, as the cycle of federal court is continuing against the cops. And we have Judge Williams, who now had the video and audio. And in August of 24, was asked to have virtual court to sentence me and to order real-time transcription and to, move his case along or dismiss it for the fact that it was withheld under New York's enhanced discovery laws, Maryann, that the cop not only was denying the accommodation, not only said I wasn't guilty 4 times. In New York, if you don't have intent to commit a crime, you can't be charged with a crime. But to have a report from the Attorney General of New York, Letitia James, on the only cop she found pattern misconduct in Westchester after her 5-year investigations of cops on the New York's Law Enforcement Misconduct Social Investigative Justice Unit. Only cop determined to qualify as pattern misconduct in Westchester. And one of only 36 of the entire state that he's pattern malfeasant, pattern liar, pattern false abuse, doesn't know how to communicate with people, is rude, and is pattern against disabled people. And the Judge Williams just says, I'm not processing it. I'm not doing it. You come to court, you get sentenced, everything's denied. So then something happens, Maryann. Once we got a new DA, DA Kachesi, who is formerly Judge Kachesi, she hired the chief of staff of the court system called Nancy Barry. Nancy Barry was the head of Westchester Executive Administrative Court and head of New York's court. She was the highest non-judicial executive of the court. The reason I know this is she is the one who denied my accommodation and said I'm not hearing impaired enough. And she also said it's going to be court policy not to sentence you virtually while you still, quote unquote, have a warrant. I said, warrant for what? I didn't commit a crime. I came in 9 times to be sentenced. I got sick. I'm immobile now. Warrant for what? So after DA Kachesi hired her as chief of staff, I asked again to Judge Williams to sentence me virtually, and he said yes. He said yes. So supposed to be sentenced actually on my birthday, August 21st, after Judge Williams then ruled the camera and the exonerating evidence and the Attorney General report don't matter. You're still guilty. Okay, sentence me. So he says he's going to sentence me virtually August 21. He says I'm not a fugitive. I appeared virtually, and it's just a misdemeanor. Maximum you can get is a year in jail. And then the DA carries on August 21st and 28th, wastes 2.5 hours telling the judge doesn't have authority to sentence me virtually because I'm faking my disabilities and people have to be in person. And I'm such a domestic terrorizing rapist ex-husband that he needs to give the max and have me in person and chains and handcuffs. And the judge said, Mr. Fishman is here. There is no warrant of arrest. He is here in person. I grant the accommodation. And the DA says, I want to see the medical paperwork. And the judge says, denied. Well, the DA says, I have to be able to see it. The judge says, medical paperwork's confidential. This court has granted the accommodation. Oh, you can't do that. You can't sentence in this way. And the judge then stands up and says, I'm the one sitting in this robe. You don't like it. You can exercise your appeals rights. Oh, well, we need a German humor. You just have said that you haven't sentenced Mr. Fishman now for 7 years, that he hasn't appeared, where he's given this court evidence he's appeared 9 times. This is a misdemeanor. Maximum you get a year. He's got no priors. You want a German. Why do you want a German? Oh, we want the victim to testify. You want the victim to testify? Why is your victim here? Mr. Fishman, I noticed this court in June and July. So did you. Why don't you have it? Now, we want the victim to testify. The victim's got to tell about the atrocious behavior that she has witnessed and received from Mr. Fishman. And by the way, we want to re-argue that he is not disabled, so you can't accommodate and want the medical information. Judge said denied. But you know what? You can bring your victim on the 28th. Mr. Fishman, you can appear on the 28th virtually. I wish you good luck with your surgery, which I had time. Appear on the 28th. The judge says adjourned. The DA says no, she's not available. We'll now do it September 10th. Wait a second. Maryann, we've already waited 7 years to be sentenced. 7 years order of protection. Okay. Judge Williams has already said that he's going to sentence virtually. The DA's doing everything. Then on sentencing day, September 10th, the ex-wife does not show up. The victim. She doesn't even show up virtually. And the DA is asked to read her statement.
Oh, no.
And for 2.5 hours, I'm listening to the statement, not being able to go to the bathroom, 2.5 hours of how a DA makes up lie after lie and actually says that Miss Solomon is traumatized that I go on podcasts, including yours. Wow. Last I knew, Maryann, if you don't like to watch a TV or don't want to hear Roger Stone or don't want to hear WABC Radio, don't want to see Maryann Petri, you can change the channel.
Right? All you have to do is push a button and then we go away.
She's traumatized because Mark goes on podcasts to help other disabled people. And it's just so horrible that he is such a criminal. And the kids are doing so well without him. And, and the DA makes the case say the Solomon kids. My ex-wife is Jennifer Solomon, not the Fishman kids. My name is Marc Fishman. And you say to yourself, you're just sitting there, taking this all in. And then you realize this has nothing to do with a conviction. This has nothing to do with a visitation. This has nothing to do with my ex-wife. This has to do with Mark sued the judges. Who is the chief of staff for DA Kachesi? Nancy Barry, who is the chief executive of the entire court. I'm not going to get anything fair. We asked the judge to remove them in April. He refused. Can't be anything fair here, Judge. This conviction should be tossed. They still haven't even acknowledged the DA's office that says a malfeasance report from Letitia James. Letitia James, who didn't write a malfeasance report on any other cop in Westchester, who only wrote on 36, and they won't even mention the case or mention the name. I said, this should be dismissed. And, they keep on saying, no, he should get the max. She should get a permanent order of protection. She should get 10 years order of protection. She should get police stay order for the kids. The judge says he wasn't charged or convicted for the kids. No, the kids are victims. And then they pretend to read statements from the kids. My kids don't talk that way. My autistic son definitely doesn't talk that way. Those were statements from the DA. Okay. The DA who admitted the conviction's defective because I was convicted of attempted and actually violating order of protection for not going on someone's property. You can't be convicted of 2 crimes for 1 event. You can't be convicted of actual if you didn't go on a property on an unserved order of protection. I know distance, stay away. So the DA said the conviction is defective in 21. Why don't you dismiss? Oh, Marc Fishman sued the judges in federal court, didn't get dismissed, and he got an order for accommodation. We can't dismiss against him. We got to protect the judges.
Well, with the DA reading your children's statements, that could be hearsay. What are they reading? Where did it come from? Who wrote?
You said it totally. They were giving on theater and drama. Because in the Bronx of Manhattan, for a misdemeanor first time, offense, you probably wouldn't even get jail time. You probably wouldn't even get an order of protection. You probably get it. You're spending the entire morning of a Westchester court reading statements and over and over again, pounding it from the head of domestic violence for the whole county against disabled Marc Fishman. Disabled Marc Fishman has trouble holding a pencil, trouble walking, and this is what you're doing after Judge Ray ruled parent alienation happened, after credit was already given for support, after now the judge in the case against the cops had said, Mr. Fishman is disabled under the ADA. Mr. Fishman is disabled under New York human rights laws. The cop need to accommodate. The cop knew he was disabled. The accommodation was not unreasonable. So wait a second. Now I graduated this, and yet we're still going by a DA who's ignoring. Who's the DA? She's a former judge. Who's the third highest DA? She's the the head of the chief of staff for DA Kachesi and formerly head executive for the courts. This ain't going to be fair. This is a lynching. This is a political lynching, you know. And so the judge then allows me to speak, which I'm lucky I was virtual because, my attorney just said, we'll leave it up to the appeal, but I'll let Mr. Fishman make his case. But so many things the DA said is false. No facts behind it. And I can speak for 20 minutes, and I got to say that this is the biggest lynching since the Supreme Court Judge Thomas endured his barrage of accusations with no evidence, no proof. And I said, there's no way my autistic son wrote that speech or spoke that way. He doesn't speak that way. And he has the skills to. There's no way my daughter in any way spoke that way. And this is all the court exercising court disability parent alienation. Mm-hmm. Because once I win my federal litigation in court, my lawsuit against the cops, a lot of people are going to get fired. A lot of people are already been fired. And what it says is it's sad that someone who's had the fight to be alive and had all these surgeries and implants and infections, cancer survivor, heart disease survivor, neuropathy survivor, has to waste his time fighting just to see his kids and just expecting the other side to say, you're never going to win, so don't try. And now, having appealed that decision where a judge said you were going to get 45 days in jail and 1 year order of protection for your ex with an anti-menacing clause, an anti-harassment clause for your 4 kids. 2 of my kids are over 18. What harassment menacing? No. Anything that I do is considered menacing by my ex-wife. Anything is considered harassment. So basically, it's 1 year order of protection. That was September 10th. We immediately appealed that to Brooklyn, to stay of the jail sentence, with medical testimony that I could be, as you said, murdered in jail without the specialized medication or therapies I get, given I now have AFib, a cancer survivor, and now I have, chronic gallstone disease and some stones, that this would be devastating. You don't have the care in the county. You won't give me the care. You don't let me access to my aides. So putting me in there and not restricting me to my medication and medical therapy could be, as you said, mortal. What you said before could be murder. Not to mention the warden doesn't want me because the cost of care was just huge. And, so Judge Love was given this at the Brooklyn Appeal Court. He denied it. Okay. Then I thought that was, the end of the road, that I'd have to, somehow drive back to New York because I can't fly with these conditions, and decided to appeal to the Court of Appeals with the hope they would take the appeal. Court of Appeals, New York's our highest court. They only take things on permission. And I'm happy to report to your audience that Judge Cannataro accepted my appeal of the stay and is granted expedited. That's the first on the Maryann Petri show. He granted expedited review this past Friday and told the DA they have to respond till Thursday as to why the sentence shouldn't be stayed and why Marc Fishman's appeal shouldn't allow to be processed expeditiously. And the DA has until November 13th at noon to respond. Okay. So we're asking your audience, who has been so gracious to me, to again come out and help and voice concerns. We're asking for letters of support to Judge Cannataro to be sent to us and to our press team. And so the email is press, PRESS, at newrochellepoliceabuse.com. That's PRESS at New Rochelle, NEWROCHELLE, police abuse, POLLICEABUSE, press at newrochellepoliceabuse.com. We will include all of your comments in our submission to the judge, which he's allowing us to supplement as long as we receive it by this Wednesday. So any comments you have about how you feel that, family court and criminal court are unfair to parents, or that we don't want to be lynched, or that your son or daughter wasn't accommodated in family court, or your own experience, we want to hear from it. Please feel free to email. No email is too short. No email is too simple. No email is too complicated. We will also be doing rallies and protests. We'll be joining with other nonprofit organizations to spread awareness. We're happy that NYLCP, New York Lawyers in the Public Interest, in their letter to incoming Mayor Mandami, said their 4th highest priority for the entire city of New York, the 4th highest priority is accommodations for disabled people in court. Very moved that
Oh,
that is so high on the list. It's a shame. You know, people think that if you're in a wheelchair or if you're in crutches, you know, or if you're in an automatic scooter, that, oh, they're going to have a courtroom that's accessible. New York State still has courtrooms without ramps. New
oh
York
my
State still doesn't have
God.
handicap accessible bathrooms in courtrooms. We have over 3,000 judges. We have some part-time courts in some barns upstate, literally. So if you can't access court, how are you going to possibly get any justice? You know, and you know what they say, Maryann, oh, the judges are immune, and oh, the court, we're trying, it's a big budgetary thing, or oh, you know, oh, it doesn't matter that, you know, how are you getting on the subway to take the train to court in the city if the subway has no elevator and the subway is on an elevated platform? So, you know, we're working with other disabled organizations because access is still being denied. And in my case, this is all about a lynching and throw someone in jail and try to get someone to deny his federal rights after now with the exposure of the attorney general, you know, who's got a lot of attention on her. You know, the fact is that she wrote a report of misconduct on the cop that falsely arrested me. And you can see the story at newrochellepoliceabuse.com, newrochellepoliceabuse.com. But she omitted my story. Now, while she was investigating Schlesinger and deciding to omit my story, she was defending Judge Shower, D'Ambrosio, and Nancy Barry
Mhm.
in federal Second Circuit Court in the Supreme Court. Wait a second. You don't disclose my case in the report, which exposed Schlesinger because he gave 6 years of discovery of his malfeasance, okay, in your report. But in every other one of the 36 reports on every other cop, you disclosed every false arrest, misconduct, federal lawsuit, state lawsuit against them, but you omitted mine. And when we go to Tyler Nims, the associate attorney general say, please amend it to include me. Oh, we can't do that. Why? You amended it for 2 other people. Oh, well, we can't do it for you. You can't do it for me? Why? And I said, did you know about my case? Oh, no, we knew about your case. Of course you knew about my case. You're investigating Lane Schlesinger, a 17-year tenured cop, and I'm all over the internet suing this guy. And a judge, Judge Roman, okay, a libertarian, orders Lane Schlesinger served after Lane Schlesinger evaded personal service for 2 years. He said you're intentionally evading service. Now we know now
For
why.
2 years.
For 2 years, right. And yet you are over here saying you won't disclose my case. No, you were told not to disclose your case by Letitia James. Who's Letitia James? She's buddy with the mayor, Yadira Ramos, at Columbia. Who's Yadira Ramos? Yadira Ramos is a racist mayor who hates Jews, who marched with the Palestinians at the Columbia protests, Columbia that was sued for discriminating against Jews. Who's Marc Fishman? He's a disabled Jew. Oh, okay. So Letitia James isn't going to disclose the report. Who's she protecting? The cop, Lane Schlesinger, who's forced out, okay, gets $92,000 a year in a pension, okay, not charged criminally for denying the accommodation, not charged criminally for perjury, for holding up the cameras that didn't exist, not charged for holding up the audio, okay. The DA and New Rochelle are not, held accountable for failing to give a disciplinary record. The disciplinary record of Schlesinger was 25 items addressed by the Attorney General report, but not listed. There's since been over another 27 found to our investigation. But no disclosure. But wait a second. Judge Williams and Judge Zuckerman find there no grounds for a new trial when all this exonerating exculpatory evidence, Maryann, which is required in enhanced discovery, was just not given or wasn't given to Marc Fishman for one reason. So Marc Fishman sued the judges in Westchester. He got a federal order. He got marshals to go to their houses. Oh, how terrible. He can't get due process. So why don't you get me out of Westchester? Oh, no. He's going to be labeled. He'll never see his kids again. He'll lose in the appellate court. He'll never get access to his kids. Won't get access to his school records. Oh, we'll send him back to shower, because, she wants retaliation. She wants retaliation against that disabled Jewish boy who she threw in jail for 2 weeks, who sued her in federal court successfully to get an order for accommodation. She wants another bite at the apple, right? And, we don't care because, Bob Temjecki at the Commission of Conduct won't do his job.
Mm.
Hector's appellate court? You think Hector's going to rule in Marc Fishman's favor? Oh, I can sell you the George Washington Bridge for $1. Hector's never going to rule anything. Hector knows that I campaigned with the state senators, and he became the first candidate for head court appeal judge to be elevated, to be denied. Hector was evicted from his confirmation hearing. Hector was denied by other Democrats. He's Democrat. Who all said your civil rights and disability record is atrocious and doesn't follow the values of the state Senate or Democrats or Republican. to have your chief judge would be scary because you don't protect the most vulnerable, the disabled. And Hector downplays, no, the circumstance of the cases vary, it's that, whatever. No, if you don't accommodate disabled people, and the accommodations in my case, Maryann, don't cost anything. Maryann, you flicked on the switch in Zoom, and I have closed captioning. Okay, in the court system, you turn a switch on, the screen appears, you get closed captioning. You either do it or you don't. Okay, if you don't, it's kind of cruel to those of us who can't hear. But when you don't do it because it's retaliation, because we publicized you and we sued you in federal court, got an order, and guess what? That's retaliation. We'll go back to federal court. We'll get more orders.
And that's what parents are so afraid of, is this retaliation that, look how long your case has been dragged out.
You said it, Maryann. And listen, I cry. I cry a lot of evenings. It's very hard being separated from my kids. I love you, Joanna, Jonah, Aiden, and Sky. And to not be in your lives, to not have memories, to not make special memories, it's absolutely no words. But I will tell you, there is solace in helping others. You get a call from, literally, I got a call from someone in Northern California. And they said, Mark, I want to thank you for your advocacy. Because of your order, I got accommodations. Because of your order, I was able to bring my best friend to be a note taker in court. And I was terrified to be in court. But, I could bring my friend as a note taker, and suddenly I'm less scared. So thank you.
Awesome.
And you hear these stories. They call you and say, Mark, I'm asking a judge in Minnesota for a jury in Minnesota. And I said, look, that has been granted before, but don't let any glass ceiling stop you. They're accusing you of some act. Ask for a jury. He says, you know what? I did. I cited your case and a couple others you referred me. And the judge is actually taking a couple weeks to think about whether he wants to give me a jury or not. I said, that's awesome. That is awesome. And they said, you fight for all of us.
Yeah.
And, Maryann, just like, you did time in jail and you had health ailments and stuff. This thing's bigger than you and me. You got to help others.
Definitely. I mean, this whole thing serves as a warning to help others to stay
you
out
said
of
it. And our Court of Appeals hasn't taken up a disability decision, last year. And the truth of the matter is, why should disability even be factored in an adversarial proceeding? It's easier to get accommodations now than it was years ago. I've also had a lot of victories, privately in insurance arbitrations or civil cases because, I sued for accommodations and won them. I would trade that all in just to hug my kids. I mean, I don't want to be, in this situation, But like you said, those of us who have made impact federal litigation have to continue it and have to, lead others, which is why I now have a team helping me. And I'm happy, recently we got an op-ed in the Washington Post, Invisible Disabilities Week, about how these accommodations are just denied frequently and they're rampant. We've been in Black Westchester. We've been on the Sal Greco show. And, even people like Roger Stone, talking about how sad and how atrocious it is that an attorney general, who in our case is the highest law enforcement official, the highest police officer, just looks to cover up and protect disability discriminating judges. And think about it. Judge Cannataro was a 23-year judge in Westchester, originally a Republican, now a Democrat, before she became DA. Do we honestly think a DA who's a judge, who's all friends with Michelle Shower, Susan Capici, David Zuckerman, Judge Maurice Williams, is actually going to give fair justice in the DA's office? We wrote to her Conviction Integrity Unit. She writes back, Mr. Fishman, your case is not ripe for a conviction integrity review. Well, Maryann, I'm not a farmer. I do like fresh fruit and vegetables, but you know what? There is no riper case than mine with the only malfeasant cop in Westchester who was designated by your bunny, Letitia James, after 29-month review, that everything he says is false, pattern misconduct. There's nothing better than my case. Why isn't it ripe? Oh, because we'll take some judges. Oh, you mean Judge Cannataro? You had some of those New Rochelle cops in your convictions when you were a lower prosecutor or judge. So make you look bad, you have to reverse them. That's why they call it clear wrongful conviction. Clear wrongful conviction. Oh, we can't do that. Why not? And think about New York, Marion, so sad. In California, we have a clear wrongful conviction act. In New Jersey, we have a clear wrongful conviction act. In Illinois, where there's a process where someone can clear wrongful conviction when there's exonerating evidence found. In New York, Governor Hochul vetoed it. We don't have it. There's no mechanism. You want to go to appeals court judges who discriminated, who we sued in federal court, who got federal orders against, who now have our cases and think that they might get some humility or some sense of justice rule in your favor. Who are you kidding? We're back in federal court to get accountability for the cop in New Rochelle, okay, who discriminated. We're back in federal court with others to get accommodations, and we constantly are in communication with the State Senate Judiciary Committee about how important it is. I mean, Maryann, let's just talk about in a plain layman sense. George Floyd, like him or hate him, is dead because he was disabled. You could tell by his breathing problems. He had 4 cops on him denying him air, okay? If he wasn't disabled, even with the 4 cops on him, he wouldn't be dead. Might be very injured, but he wouldn't be dead. So what was the whole Floyd thing about? Disability discrimination. The head cop who's doing time in Arizona Federal, Chasen, right? He said he knew Floyd was disabled. He said he knew of Floyd, okay? So why the hell would you be trying to kill a disabled person on the ground with 4 large men leaning on him without accommodating him? When you know he's disabled, you just could have handcuffed him or just held him till an ambulance arrived.
Right.
It's because you discriminate against disabled people and you believe in retaliating when they do it. And when the crowd wanted to help the disabled person, the Chinese, Asian cops, no, you can't help him. What are you talking about? You can't help the disabled person. I mean, ridiculous. Everyone wants to help the disabled person. So when you punish disabled people, when you keep veterans, dads and moms away from their kids, you hurt us all. You hurt all of our parents. All of us as parents, we have to speak up. We have to continue fighting in federal court and continue, marching and protesting and promoting equal shared parenting and talk about what's going on in court, that a lot of us are being tried for our disabilities, invisible, and a lot of us being persecuted and condemned and limited access to our kids or racing access because we were disabled, and we raised the issue of discrimination and raised the issue of a need for accommodation. Got to keep doing it.
Definitely. I'm so glad you spoke out.
Thanks for giving us the forum. So glad you spoke out. People like you coming before us. We are following your footsteps, Maryann. We'll have a book next month talking about, with evidence, all the cover-up by Letitia James in this case. Letitia James can end my persecution tomorrow. All she has to do is amend her report to include my, false arrest, to include the camera footage, to include the disciplinary reports, and include a federal lawsuit. She chooses not to. So what the federal attorneys for New Rochelle said, if Mark's not listed in the report, then it has been determined that Officer Schlesinger discriminated against Mark. What are you talking about? I had to sue you guys in federal court to get the 9 hours video of your police precinct exonerating where he said I'm not guilty. I had to sue you to get the 3-page order of protection because you convicted me of 2 pages saying I wasn't served. I said, what are you talking about over here? I said, you think a federal appeals court is going to let you escape this? Let me tell you something. These federal judges, I give them a lot of credit. They're elected for life. Most of them, really care and have a conviction to give fair justice. Most of them give us equal time to talk, Maryann, in federal court, federal appeals court. They're not rude. They don't exclude evidence. And most of them want to do the right thing. And to be a federal judge, you got to get a majority of 100 senators. And like we see, Maryann, in the current shutdown, to get a majority of 100 people to agree on anything is quite hard. They're having trouble getting 60 people to agree, right? So for someone to be a federal district judge elected for life, you have to say, you know what? They really want to do the right thing. So I have faith in the majority of federal judges that'll do the right thing and stop the discrimination in state court for all of us with disabilities and without. And amen to them.
Exactly. And I want to encourage everyone again to send a letter to press@NewRochellePoliceAbuse.com. Thank you so much, Mark. Don't jump off, okay?
Thank you. Thanks for having me.
Well, thank you. Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri. You can find me on Spotify, YouTube. Please like and subscribe, Apple iTunes, iHeartRadio, Google, and other platforms I don't know about. Again, feel free to buy me a coffee to help keep this podcast going. Thank you so much, Marc Fishman, for your bravery in speaking out and going through things you should never have had to go through.
Thank you. God bless you, Maryann.
Thank you.